She ruled the Myriad decision in Australia, and in her decision she wrote, adapting the reasoning of Frankfurter J and Frank Brothers C Company, it's a US Supreme Court decision, it confuses the issue to use such terms as the work of nature and the laws of nature. It is not decisive or helpful to point out that the suggestion is that nature be allowed to work on its own way. Expressions such as the work of nature or the law of nature could be employed to challenge almost every patent. And I agree with that, but of course there is a line between discovery and invention, and Justice Bennett has also addressed this, and she said there's a distinction between the discovery of a law of nature and the application of such law to a new and useful purpose. And I couldn't say it any better, because I think that's the line where you take it out from nature and provide it for the very first time for a use to mankind. It was hidden, not known before. Then that should be the line between the discovery and the invention, and it should be patent eligible. So having said this, let's go to the European point of view with respect to naturally occurring compounds. First of all, to be patentable, biotechnical inventions have to meet the same criteria as those in any other field of technology. They must be novel, they must be inventive and susceptible of industrial application. Now we can ask, how can this be novel? Because it's just there, it's in nature. How can you call it novel? Well, the legal definition of novelty is it was hidden. Therefore, it's not novelty destroying. So it's a legal definition of what is new, new in the sense of making it for the very first time available to the public. And also the European Patent Office states that it shall not be patentable if you have a discovery, a scientific theory, and a mathematical method. So in general, natural compounds like small molecules, antibodies, DNA, proteins, peptides, isolated from nature are patent eligible in the European Patent Office and also in the national patent offices. And also in Germany, there's a long history of case law which I have cited here, started with Midazoline, which states that natural products are patent eligible. So even microorganisms used in cabbage fermentation may be patentable. And the line which the Supreme Court draws as well in Germany, that there is discovery, but specific manifestations and or isolations can render these natural compounds patentable. And of course, they need to be novel and inventive, novel in the legal sense I have just mentioned. Let's come to some limitations to patenting natural products. Let's come to genes. You find in the European Patent Convention that the human body and genes as such are not patentable, but then Rule 29(2) states an element isolated from the human body or otherwise produced by means of a technical process, including gene sequences, constitute a patentable invention, even if the structure of that element is identical to that of a natural element. So that they made it quite clear, and if you come back to the theory, yes, it is true, this gene sequence was somewhere in the genome, but it was hidden, it was not taken out from nature, provided to mankind with an industrial application, and in this case, the industrial application is the function. You have to identify a certain function. And the Court of Justice of the European Union went a step further in a decision which was concerning the enforcement of gene patents. That was a gene patent of Monsanto about a gene-modified plant, a soybean, and the claim comprised the gene sequence. And the product which came on the market, the alleged infringement product, was a downstream product, meal or whatsoever, from the soybean, and still it had some leftovers of the gene in it. And the question is whether this would constitute patent infringement. And the court said the protection of genes is not available when the genetic information has ceased to perform the function it performed in the initial material from which the material in question is derived. So there's like a functionality gatekeeper for genes. So an essential requirement for patenting gene sequences is function, function, function. So in the patent applications you should be specific, you should specific name the epitope, which activity, which receptor is expressed, don't give laundry list, and it must be credible that this gene sequence fulfills this function. So no speculations. There's another limitation when it comes to patentability of natural products in this regard, cell cultures, and this is when it comes to embryonic stem cells. So embryonic stem cells, they are these cells which are in the very initial stadium of human life, and these cells can differentiate into many other cells. So it's the first stadium, so to speak, the embryonic stem cells. And in the European Patent Convention you find the Rule 28, which states that European patents shall not be granted if they concern the following, and C is uses of human embryos for industrial or commercial purposes. So there was a patent, and the claims were directed to a cell culture comprising primate embryonic stem cells which are capable of something. But the application, the specification, described the use of human embryos as starting material for the generation of human embryonic stem cells, and it was stated that's being indispensable. So the question now is how narrow or how broad you have to interpret Rule 28. Are claims only excluded from patentability if the use of human embryos are stated in the claims, or would you interpret this article broader and extend the exclusion also to product whose preparation necessitates the use of human embryos? The enlarged Board of Appeal decided that under the European Patent Convention it's not possible to grant a patent for an invention which necessarily involves the use and destruction of human embryos, regardless whether or not you find this in the claims. And the same was stated by the Court of Justice of the European Union in the so-called Brüssel-case. There is another exemption to patentability when it comes to plant and animal varieties. So European patents shall not be granted in respect of plant and animal varieties, I think that's the same in India, or essentially biological processes. This is also the same in India. And what are essentially biological processes? This is a process for the production of plants which consists entirely of natural phenomena such as crossing or selection. In principle, you can patent gene-modified plant varieties or animal varieties, unless the invention is not limited to a specific plant variety. So let's have some examples of these gene-modified animals. Here you have, for instance, goats which produce in their milk tissue plasminogen activator, or other animals who produce in their milk or in their blood useful natural products or medicaments. Or you have here examples for plants which are genetically modified to be resistant against herbicides, for instance. So you could obtain patents for such plants if they are not limited to a specific plant variety. We had recently a case which concerned essentially biological processes, which was directed to a method for the production of a broccoli plant, and you had steps, crossing, selection, and the technical contribution was that the markers, genetic markers, helped you to select the plants. And it was decided that this would not lead to patentability because essentially you have natural processes of crossing and selecting. The last question, and I come to my last slide, the enlarged Board of Appeal had to answer whether plants obtained by such processes are likewise excluded from patentability, and the claims were directed to a tomato, for instance, and the tomato was, the claim was drafted like a product claim. Other claims were drafted like product by process claims, and the enlarged Board of Appeal said that although they were obtained by essentially biological processes, they are patentable. So in summary, natural products are patentable in Europe. There is no law of nature doctrine. There are certain limitations when it comes to genes, stem cells, plant, animal varieties, and essentially biological processes. Thank you very much for your attention.